Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Let's start today with a new one you just posted in Washington State. We don't have a lot of information on this, and it's a little screwy, but I like it for the point. After I get into the facts, you'll see why. I kind of like it for the point of you can only do our best sometimes, and you just can't avoid getting sued. If you're going to, if someone's going to sue you, they're going to sue you. You're never going to avoid it being in the fire and EMS service, and just relax, because other than in Washington State, you're protected by a lot of rules. Unfortunately, if you watched us, I think it was last week where we spoke about Washington State and their court system basically removing a protection, right? So this is significant. They've not this case, but last week, just to bring you up to speed before we get into Washington State has removed a protection that normally would be available to most municipal employees, firefighters, police, and said, well, we'll protect you in that if you violated a duty that was outlined in statute, we'll give you a lot of protection. I'm not trying to restate the whole thing, right? The public duty doctrine, but the court said, but if you violated a duty that was kind of owed to everybody generally and is not stated in statute, but is only stated in judge-made law, court-made law, the common law, then you do not get the protection of the public duty doctrine. And that's, you're going to see how bad a ruling that is for something like this. So here we have a woman. She was arrested for driving while impaired, or DUI. In that state, I'm not sure whether it's DWI, DUI, DUII, whatever. And anyway, it's DUI. She had 3 accidents. So she sues the police department and the fire department. And they, including the fire department, which is interesting, conclude that she was intoxicated. So this woman was driving herself to the doctor, right? So she's headed to the doctor in November of 19 when the accidents occurred. Hopefully she wasn't going there drunk, but that's the allegation. And she actually had a massive stroke, all right? So that is probably, doesn't mean she wasn't also intoxicated. I'm just throwing that out there, right? But she actually suffered a stroke. So she left the scenes of the crashes. She was apprehended by the police in the waiting room of her doctor's office. She actually kept driving, leaving the scene of the accident, which is amazing. But hey, maybe she wasn't in her right state of mind if she actually had a stroke. Anyway, they get her into her doctor's office. Everyone must be thinking, isn't there any confidentiality? But different issue. In any event, the police request the fire department to come. Now, this is, again, a really interesting issue, because determining whether she's intoxicated or otherwise is not a fire department function. Yet here's how the police are using fire, right? So the police, which is super interesting, and you and I, Curt, have had a long history over this year, and you for many years before this, talking about police versus fire, right? So here's the police department requesting the fire department to respond to a medical office where there's already a doctor, and note, the patient didn't call and the medical provider didn't call. This is the police who called. So there are so many interesting issues. Any event, apparently the woman's blood sugar and vitals were normal. And so based on that, the firefighters concluded she was not in any medical distress and that she must have been under the influence of some unknown intoxicant. Now, look, that's a big freaking stretch to be able to make based on a couple of factors, right? And again, the police have field sobriety tests, which are 82% predictive value. Why isn't that being done if she's intoxicated, right? You don't need the fire department to do that. Nonetheless, the police arrest her and charge her with DUI. She was out on bail 8 hours later, but that doesn't mean anything today. Her family was apparently told that she was acting goofy, that she was high on drugs, but not in any medical distress. That could be stroke. That could be a lot of things, right? So they were then told to wait 24 to 36 hours for signs of drug impairment to lessen. makes a big assumption again that she was actually impaired by drugs. Her brother brought her finally to an urgent care where she was then rushed to the emergency room. And then she was determined she had a massive stroke, leaving her in a near vegetative state, right? So something happened since that. So that's all we know at the moment because we don't yet have a copy of the complaint. But think about how incredible this is. The police pull her out of a medical provider's office who would have performed a competent medical exam far beyond the abilities of a fire department rescue squad or EMTs, would have been able to render a medical decision, right? Why are the police calling a fire department in? Now, I'm going to give you an answer. Because they couldn't ask the doctor. If she went into the doctor's office, right, and the doctors performed an exam, they HIPAA, right? They can't ask. But what they probably could have done is said, listen, if she's drunk, right, then this. Well, wait a minute. So why didn't you perform a field sobriety test? I don't know.
A lot of questions.
It's so many questions. This is such an incredible case.
But, I think what kind of concerns me here is that the medics apparently didn't assess for stroke. Now, certainly the most logical reason why someone may be acting impaired, especially if she's 56, 55, 56, is, a question of diabetes. That's a legitimate, it's on the table. They rule that out, which is good. You would think, diabetes requires a little bit more of an involved assessment than would a stroke. There's pretty simple,
Yeah, you got a Cleveland test, right? Do the Cleveland test.
Some of which you're just looking at the person, squeeze my hand, all the different things that we can do for someone with a stroke. Now, if she wasn't displaying any of those, then it gets to be a little bit more complicated, but very, very difficult area. And you're absolutely right. It's funny. I wasn't putting this week and last week together, and you did. And we did talk about Washington State, and certainly the public duty doctrine would have been a defense if the Supreme Court hadn't really,
not anymore.
Given it a haircut there. So,
and I got to tell you, so many questions go through my mind. I'm so fascinated by these facts because, for one, how did they get her blood sugar? Against her will? Or right, she's sitting in a doctor's office. So did they keep her from her medical provider? Yes, they could have arrested her, but my God, she's at her doctor's office. Maybe it was just a normal medical exam. Maybe she was driving there because she didn't feel good.
And I think the cops were in a tough spot too. They feel that they've got 3 accidents. And here's this woman sitting in the office. It's obvious she is the one that caused the 3 accidents. So they got all this. Maybe the fire department had to respond to those other ones, and they weren't very happy about somebody having 3 hit and run accidents and continuing. Who knows? But at the end of the day, we got a woman who's very seriously ill. And it's a funny thing. I have been searching Lexis for the complaint. I checked it again just before we logged on. There's a complaint filed by the state of Washington against her. But that's the title of the case. But under the listed plaintiffs, she's listed as a plaintiff. So I'm wondering now, she is in state care. Hear me out here. She's in state care. Her brother is apparently in the process of being appointed, or has been appointed, her guardian or conservator. But she's no longer in a private institution. I'm assuming that the state has put her in because no funds, they put her in a state institution. The bottom line is it may be the state that actually filed this suit. Now, there may be an additional suit, but last week on January 17th, the title of the case is State of Washington versus.
That sounds like a criminal people versus, right?
Almost. Yeah, no, it's a civil case. And I tried to download the petition, and there's several documents that were submitted on January 17th, but apparently they're not accessible. So certainly if we can get a copy of the complaint, we'll get it posted, and then that'll give us a little bit more detail on it. But I want to even know, was she given a choice to have her finger tested, right? I mean, was she competent or was she assaulted? Did they just say, here, the fire department's going to test your finger? And
all this just, it's an incredible set of facts to me. I love it.
Yeah, it is. And it'd be interesting to see the allegations. I hadn't thought about the assault aspect of it, but you know, certainly if she's in custody, now we've got a bunch of other issues. And
Right.
I don't know.
Right. Where the police may be protected by a public duty doctrine because the power to arrest is provided for in statute. So who knows?
And there's obligations. Like once the police take someone into custody, they have certain obligations to make sure any of their medical needs are met, because the person obviously can't go to the doctor. And if they're in, you know, need of medical attention, it's up to the authorities to get that attention. I think it's an Eighth Amendment issue. So, you know, it'll be interesting to see how it comes out.
Very interesting. Just if I was the fire department, I'm not sure I would have agreed to do all that. But I understand the police call you, you want to be helpful, but